Hi everyone, welcome again to another tech webinar that we have here at Lewis Parker. Today's webinar is titled Buying and Selling Home Health and Hospice Agencies. Our speakers today are Jennifer and Heidi, and I'll leave the webinar to them. We'll start with a little introduction about themselves and then we'll start the webinar.
Hi, this is Jennifer Papapanayotu. I'm an attorney with Lewis Parker. I'm physically located in Houston, Texas. I've been doing this for about 21 years now, and my practice focuses a lot on transactional work for home health and hospice agencies, along with lots of other kinds of healthcare providers. And then I also do a fair amount of work on the enrollment and certification side for Medicare and Medicaid providers and licensure work for licensed providers in the state of Texas. I'm joined today by my partner, Heidi Kocher, and I'm going to let her take it over from there and get us started.
Thanks, Jennifer. So I'm Heidi Kocher. I'm a partner with Lewis Parker as well. And while Jennifer is down in Houston, I'm actually up in the Dallas area. So between the two of us, we can pretty well cover Texas, I think. I've been doing this for 20 plus years as well, and have had various positions both in-house and in law firms. While Jennifer has said that she focuses a lot on the transactional aspect, I guess my focus would be more on some of the regulatory and compliance things. So I've done a lot of work with home health audits, TPEs, ADRs, that kind of thing, as well as transactional and regulatory work. And that kind of gives you a flavor of who we are. And so with that very brief intro, we're going to go ahead and plunge right in. So we have the table of contents. We're going to talk a little bit about trends and transaction basics. Of course, since we're lawyers, you know we have to cover the healthcare laws, Stark and Anti-Kickback. What would a webinar be without Stark and Anti-Kickback? Important steps and documents, post-closing issues, and then some very special considerations for home health and hospice. Next slide. So one of the things that we're going to talk about is some current trends. One of the good news is that the CMS moratorium on initial home health certifications has been lifted. Yay! So I think what that is going to do is we're going to see a shift. We might not see as much buying and selling of home health agencies as perhaps people trying to start their own ones, but certainly there's a lot of value in buying an established home health agency. One of the things that we do want to point out is that RAP suppressions are likely to be imposed on agencies with true change of ownerships and 100% share or member interest transfers. And if you kind of understand where CMS is coming from, they're probably going to do that to make sure that they know who the buying parties are, and it takes them some time to do that. So that's something you need to kind of keep in the back of your mind. We couldn't mention anything to deal with home health without mentioning that the pre-claim review project is back on. It began in Illinois on June 1st. It will begin in Ohio on September 30th. Yeah, weird date. We don't have a formal date set for Texas yet, although the rumors going around are that they will probably make an announcement before the end of the year. And providers have to be given 60 days advance notice before that starts. So again, we're looking for that notification sometime in the next quarter. Integrity auditors are very, very active. We do see a lot of suspensions, revocations. TPE is going into its second round. I see a ton of ADRs for home health stuff, which is all very much like sort of the pre-claim review process. And of course, criminal prosecutions, at least for me up here in Dallas for healthcare fraud, has been very active and continues to be. You may remember Dr. Roy Jacques, who had, I think it was 11,000 patients that he signed certifications for, and literally hundreds of home health agencies connected to him. So that sort of suspicious background that regulators bring into home health is still out there. And you need to keep that in mind when you're doing a transaction. Next slide. So we're going to go over some basics and a couple of things to think about these. One of the things is that a transaction in the healthcare industry can take months to complete. This is not a thing where you can get it done in the space of 6 weeks like you might be able to in some other business. Because of the regulatory issues involved, it will take easily, I've had transactions take 5-6 months sometimes because of all the regulatory issues. So you need to prepare for the long haul when you are going into a purchase or sale transaction. Again,
Jennifer,
because we've got...
Heidi, if you don't mind, can I interrupt for just a second? That's not
Sure.
to say that we can't do a deal in 30
Right.
days. It's just that when I say, it's regulatorily driven, it's also due diligence driven. And
Yes.
I'm often having to convince people to engage in some substantive due diligence in advance of a deal. And that can take time. And it's worth it to invest that time to learn about the business and really understand what it is you're getting yourself into before you pull the trigger and own the business. And we'll get into some more stories later on, but the reality is we have more than one client who's come to us who didn't really do their homework deeply, and sometimes they did. And a month or 2 or 6 after they close their deal, they get an audit request. And it relates back to a pre-closing time period. And, maybe it's an issue you could have discovered in due diligence, maybe it's not, but it's worth it to do your homework and learn as much as you can about an agency before you buy it. And there are some deadlines and notice periods we simply cannot work around. You have to comply with whatever the state regulations are. So with that said, Heidi, take it away.
Yes. Yeah. Jennifer's right. It's not that you can't get it done in 30 days, but if you want to get it done in 30 days, you need to be basically doing nothing but for 30 days, and you're going to be relying on people like accountants, valuators, and attorneys to help you get it done that quickly. And that actually leads to the third point, which is hire a lawyer. I'm usually not one for beating the drum on hiring a lawyer because I don't like to toot my own horn, but we have seen, particularly with home care companies, that there are so many laws and regulations that you really need to have the regulatory help up front. And again, as Jennifer has said, we both have multiple war stories about people who didn't engage in due diligence, who didn't get legal help up front. And they're spending probably 3, 4, or 5 times on the back end to fix and clean up problems if they had spent that money up front to do the due diligence. And maybe you end up finding issues that you're willing to accept. Maybe you find issues that are deal breakers, but you really do want to hire a lawyer for these kinds of purchase and sales transactions. You should also consider retaining an accountant or a valuation expert because, again, you have a lot of assets, and a lot of these assets are intangibles. You might have hard assets that have depreciation. You have things like goodwill that are not very easily valued. So you want to have an expert on your side in terms of valuation. Next slide. As part of this, again, do your due diligence, do your homework. Don't be afraid to walk away from a deal. It is honestly better to lose $10,000 in earnest money than end up paying $110,000 in penalties or overpayments. And that is, something that can happen. A lot of deals reach a letter of intent stage, and they never close because, again, the letter of intent simply says, okay, we're intending to look into a transaction where we're going to join forces or purchase or sale. But you find facts during the due diligence process that changes it. And sometimes, it's bad enough that you want to walk away, or there's other things that happen. So you really do recognize that a letter of intent is not the final document. It just sort of gives you a period of exclusivity. Every deal is slightly different based on, again, unique facts to each transaction. They generally have the same documents and processes, but there will be significant details that can and do differ between them. And that leads into the next point. So again, many of the deal documents are to a large extent standardized and transferable from industry to industry, but you cannot pick something off the internet and fill in the blank and have it work. And again, particular situations require particular provisions. So you really can't just copy and paste. And again, in home care, we have a lot of regulatory concerns, licensing concerns that Jennifer is going to speak to. Next slide. So that's kind of the background. Okay, so let's go through some important steps and documents. And again, these are kind of in order of timing what happens when. So typically you have a letter of intent. Now, a letter of intent is an optional document, but what it does is it lays out the basics of the transaction as the parties understand that. Then you open up for a period of due diligence. And again, as Jennifer mentioned earlier, you really want to do due diligence. Do not buy somebody or an entity or even assets without doing due diligence. It will save you so much headache later on. The purchase agreement is the actual document that says what you're going to buy, how you're going to pay for it. It has things called representations and warranties, which is lawyer speak for things that we make promises about. You've got indemnifications, things that if something goes wrong, we will reimburse you for that, or we will take on the liability for it. You've got exceptions and limitations to indemnifications, and then any ancillary closing documents, such as if you have employment agreements or a medical directorship or something like that. And then after you do your due diligence and you work through the elements of the purchase agreement, you go to closing, and that's the actual event where you finally sign a bill of sale and money changes hands. Or if you want to put money in an escrow account, you open up the escrow account and money goes into the escrow account. So that's the approximate step. There's also steps that you have to finish after closing, and we'll talk those as well, but those kind of give you the idea for the actual transaction itself. Next slide, please. Okay. As the top of the slide says, stop. Again, we cannot emphasize this enough. Before you draft or sign a letter of intent or a purchase agreement, make sure that the deal you are considering has been vetted with an attorney who is experienced in healthcare transactions. I have had to get people out of messes, and when I looked at the purchase documentation, there are so many issues wrong with it, and I've asked my clients, who drew up this legal documentation? Oh, this was my sister's divorce attorney. That doesn't work really well. So make sure the attorney does have experience in healthcare transactions. Things to note that, again, federal and state laws can and do impact the terms and timing of a healthcare transaction. So just because you can do something if you're buying, let's say, a McDonald's franchise, doesn't mean you can do the same thing in purchase or sale of a healthcare entity. And again, your attorney will help outline any limitations in pricing, financing, notice periods, and other key provisions in these documents. So as an example here, often a buyer may want to extend the payment term. They may want to, do monthly or even annual payments for the purchase of the entity. And again, the laws may affect how you do that payout and what it's structured as. So your attorney can help you make sure that those are all correct and accurate. Next slide. Jennifer? Jennifer, you want to take over?
Oh, sorry, I had the mute button on. Sorry, guys.
No worries.
So this is the obligatory section on relevant fraud and abuse laws applicable to healthcare transactions. And I'll caveat this right off the bat by saying that while we worry about compliance and fraud and abuse in the context of these transactions, if we can go back to slide 8, that would be great. It isn't an overriding concern in most transactions. We'll just start off with the Stark Law. And I underlined a very key term in the very first bullet here. the Stark Law prohibits a physician from referring patients for designated health services to an entity with which the physician or his immediate family have a financial relationship unless an exception applies. And the other thing to note is the second bullet, that home health services are designated health services, but hospice services are not. So there's two important things to keep in mind with Stark. First and foremost, it applies to physicians. And secondly, it applies in the home health services, but it does not apply to referrals for hospice services. So we already have a fairly limited subset of potential transactions that the Stark Law is ever even going to apply to. If you don't have a physician involved in the ownership of a business, either on the buyer or the seller side, and you don't have home health services involved, then you don't really have to worry too much about Stark. That being said, we do have deals, especially on the hospice side, that do involve physician investment. And while we have that, since hospice isn't a designated health service, often we don't have to worry about Stark for that reason. So it's actually fairly uncommon for me to see physician investors in home health because of the limitations that exist on that under other laws. Really, physicians can't effectively invest in home health agencies unless they're in a rural area. And so we don't see a lot of that. But for purposes of sort of being comprehensive and making sure you're aware of what the Stark Law requires, essentially, if you did have a physician involved in a transaction as an owner of one of these businesses, either on the buyer or seller side, you would want to take into consideration the Stark Law and how you structure that business and whether that physician could continue to be an owner or could invest in that business. Stark is a strict liability civil statute, meaning you must comply with an exception to be in compliance with the law if the law applies to your transaction. If you don't, then all of the referred services that are considered those designated health services, which in this case would be the home health services, would be considered essentially not covered by the Medicare program. Anything you billed and collected would be an overpayment that would have to be refunded. So it's really important to evaluate very early on whether Stark's going to apply to your transaction, and then to structure it appropriately if it is. Let's go to the next slide. There is an exception for isolated transactions under the Stark Law, and this is a brief summary of what that transaction exception requires. The total payment has to be fixed in advance, or the formula for payment has to be specified. The price can't take into account the volume or value of referrals. The transaction has to be commercially reasonable, and there can't be any other transactions between the parties for 6 months unless those transactions meet another exception under the Stark Law. So honestly, it's not terribly difficult to comply with Stark as long as you follow this isolated transactions exception. And again, it's a very small subset of transactions where this law really comes into play. But let's go to the next slide and we'll talk a little bit about the anti-kickback statute. It really applies to everybody. So the anti-kickback statute is a criminal law, and it prohibits the knowing and willful exchange of anything of value to induce or arrange for referrals payable by Medicare or Medicaid. So transactions among parties who may refer to each other are subject to the anti-kickback statute. And if we go to the next slide, we'll talk a little bit about what this really means in the bigger sense, and I can try to give you some context for how we look at the anti-kickback statute in a transactional environment, and especially in home health and hospice. The reality is, I would say 90% of the time when I'm working with either a buyer or a seller on a home health or hospice transaction, the buyer is leaving the market entirely, and the seller is usually either starting out as a new owner or is expanding an existing business. And the likelihood that there will be referrals from the seller to the buyer after the transaction closes or vice versa is essentially, they're never going to refer patients to each other because the seller's retiring, leaving the state, moving to another city, or they're just not going to be in the home health and hospice business. In those situations, we don't worry so much about the anti-kickback statute. It's where you're going to have people who maybe own a business with multiple locations, or they have multiple certified businesses in the same geographic area, or you have an investor that may own another kind of business that may serve as a source of referrals to a home health or hospice business. Then we worry about the anti-kickback statute, and we try to structure as closely as we can to the safe harbors that would help protect the financial transaction. There isn't really a perfect safe harbor for the kind of home health or hospice transaction we typically see. There is a safe harbor for a sale of physician practices. This is one of the original safe harbors that was promulgated. It's the closest thing we have to apply to a home health or hospice transaction. And the important thing to keep in mind about the anti-kickback statute is it's unlike Stark, where you must comply with an exception if the law applies to you. Your failure to meet an anti-kickback statute safe harbor does not mean your transaction is illegal, and it doesn't mean you violated the law. It just means that you're not going to get the benefit of that safe harbor. And any enforcement authority that looked at your deal and looked at whether it violated the anti-kickback statute would be looking at all the facts and circumstances. So what we typically do is, we are going to counsel you to come as close as you can to complying with this safe harbor, because it gives us some useful structure for the deal and some go-bys for how enforcement people look at these transactions. I'm not going to delve deeply into what that sale of practice safe harbor requires. Just keep in mind that in situations where, for example, a seller is going to continue to be in the market and may serve as a potential source of referrals, whether they own another home health agency or they own a hospice or they own some other kind of healthcare business, it's important. Those can all serve as potential sources of referrals. So when sellers are staying in the market or going to be a potential referral source, then we worry about how we structure typically the compensation provisions in your transaction, any kind of financing, especially if something's owner financed, then we worry about how long that financing stretches out into the future. And we look very closely at the valuation of the deal to make sure that we are achieving that fair market value price for the business. Let's go to the next slide. As I said before, if a deal doesn't fit in a safe harbor, it's a good idea to engage your attorney who's assisting with the transaction on the buyer side or the seller side to essentially put down on paper their analysis of the risks associated with the transaction. Sometimes they're called advice letters. I like to call them risk analyses. They outline the transaction, look at the risks, and document what the parties have done to mitigate those risks. How have we ensured that we're not violating the anti-kickback statute and our intent is appropriate? I also encourage people, if we are concerned about the anti-kickback statute applying, to engage good financial advisors and potentially even hire an appraiser to help support the valuation of the transaction. It's really the very best proof, if you want to use that word, that you can develop that shows that a deal was fair market value and was commercially reasonable between the parties. This isn't necessary for every kind of deal, but as I said, for that small subset where you do have a potential referral relationship between the seller and the buyer after the transaction closes, we do have to worry about this, and we do need to implement some of these extra added features. And this is another thing that can draw out the timeline for your transaction. It just can take longer to close a deal when you've got to get these other pieces of the puzzle in place before you finalize things. Let's go to the next step. And Heidi, I think you were going to step in here.
Yeah, so thanks for that summary, Jennifer. So what we're going to talk now is, again, sort of the important steps and documents. As we mentioned earlier, a letter of intent is optional in that, you don't have to have it to consummate a transaction. It's a good idea to have it because what it does is it really lays out a lot of your key terms and opens the negotiation, and it helps shape the way the transaction looks. And if you guys if the buyer and the seller can't even agree on the terms of a letter of intent, you're going to have, problems down the road. Your purchase documents aren't going to be satisfactory. Now, a letter of intent is generally non-binding except for two things. Typically, a letter of intent says, we're going to do due diligence and so on, and it's going to take us 60 days, 90 days, however many days, 120 days. And so what you have in there are a non-disclosure provision and we call it a non-shop provision. So basically, non-disclosure, you're not going to tell anybody else about the deal or the proposed terms of the deal. And no shop means the buyer and the seller are dealing with each other exclusively during the period of the letter of intent, meaning the seller is not going to go and try to get a better price for selling the company to somebody else. And the non-disclosure agreement can exceed or can last beyond the terms of the letter of intent, so that's something to be aware of. Obviously, once the letter of intent expires, your no-shop provisions expire as well, but non-disclosure can often have a longer term. And again, because the letter of intent sort of sets the tone for the entire set of transactions and negotiations, you really want to make sure that the LOI is well crafted and takes into account a lot of the variables and potentialities. Next slide, please. So after you sign the letter of intent, the next step is the due diligence. And the key phrase here is caveat emptor, buyer beware. Both parties should do some due diligence. Obviously, as a seller, you want to know if there's any issues that could affect the sale price or other conditions to the sale. But the buying party really, really is the one that needs to conduct extensive due diligence, because they want to make sure that what they're buying is what they think they're buying. So you need to be doing things like investigating financial statements, tax returns, make sure there are no tax liabilities, view the operations, licenses and certifications, and all other aspects of a business. And I would add here, you also need to look at what compliance activities are going on. Just recently, I had a client that purchased an entity and was unaware that the seller had inadvertently employed somebody who was excluded. And so now we have to deal with things like, were you doing the sanction screening? Were you doing the training and education? What steps did you take from a compliance perspective to make sure that the business was running in accordance with the regulations? Next slide.
This is Jennifer. I'll interrupt for just 1 second. I know it sounds, and I want you to delve into the mini claim audit concept deeply, but just before that, I was going to add, it'll sound ridiculous, but I have had 2 or 3 deals in a row, another war story, right, where somebody was buying an agency, whether it was a hospice or home health, that essentially was kind of a naked license and certification that didn't either had 1 or 2 patients admitted or didn't have any active patients at the time. Now, setting aside the regulatory and other compliance issues that presents, the big question that always comes to mind for me is, can they document and prove up that license and that Medicare certification are in good standing? And it's a silly question. It seems like a silly question, but I cannot tell you how many instances I have found where we've gone to do due diligence on these businesses and they have not been able to confirm that the Medicare enrollment is in good standing. And it's not easy to do that because there's really no publicly available source we can go to find that out. So, you know, I have my ways that what I think is an acceptable form of documentation of that. And I'm sure, Heidi, you've got your own list of things you like to see to prove that up. But it's a bigger issue than you might imagine. It was bigger when the moratorium was in place because there was a tremendous value associated with having that Medicare certification. You couldn't get one otherwise. Now that the moratorium's over, honestly, that's become less of an issue, I guess. I've seen it less, but in Texas at least, but I've seen it in other states where it's really become, people want to realize value out of having that license and certification in place, and it certainly costs something to get those. And so there's value associated with it. You just have to be really careful when you're buying what looks to be a naked license and certification that doesn't have a lot of other operations associated with it. So just something to keep in mind.
Yeah, and I think that's a great point, Jennifer. And so one of my key due diligence questions, sounds silly, but is, why are you selling?
Yeah.
I mean,
give me the history.
People might actually tell you, oh, I've had an audit and, I have to be paying back $500,000, or, you know, I mean, you just
Oh, my favorite
ask.
one, I'll share briefly. My favorite one was I was actually working through a broker, and I started asking these questions, you know, trying to vet the agency and do our due diligence. And come to find out, after I kind of didn't get a straight answer, the seller had been indicted.
Exactly.
The seller wasn't indicted related to the home health business. They were indicted related to a different healthcare business they had invested in. But, I mean, certainly that is a relevant fact. And I had to find that out on my own. You know, part of my typical due diligence process is I run background checks on the company and the principals that own the seller. And so, you know, in addition to running lien and litigation searches, and, you know, it's not hard to find that stuff out. So anyway, war stories for another day, but let's move on.
Yeah, yeah. But anyway, so I mean, just even ask. You might be surprised what information you get. So part of the due diligence is, again, we strongly advise doing a mini claim audit. Now, you know, depending on the size of the agency, you know, the actual number of claims, you know, can vary. But even if you pulled just 10 claims, you'll get a pretty good idea already of documentation. I usually like to do 25 to 30 claims, just to get a beginning start. And again, if it's a bigger agency, then you want to do more. But the reason that you do this is, again, to take a look at the documentation, to see what kinds of patients they have. And again, remember that if you, as the purchaser, are taking on the billing numbers and the licenses, you're going to get all of the Medicare and Medicaid successor liability. So that's something to keep in the back of your mind. And again, if your claims audit shows something that maybe isn't really bad, but just you just can't put a finger on it, then maybe you want to make a provision in your purchase documents that you're going to escrow some money for some period of time. If you're doing a claims audit, it's always worth engaging an expert, because, again, I do this for a living. I have a pretty good idea of what's going on, but, you know, the experts are the experts for a reason. They know a lot of things, and sometimes it's useful to have an independent expert, again, particularly if you're dealing with larger transactions. So again, you want to identify weaknesses in the medical records and other documentation. And again, this talks about a claims audit, but don't forget to audit things like the financial transactions and so on. You might be surprised what you run into. So as we've said, you know, really big problems can reduce the purchase price. It can kill the deal entirely, or a middle ground is having a post-closing escrow that will vary in amounts. I have a transaction right now. They're looking at putting about $250,000 in an escrow, just because there are some questions about some of the billing. So things to think about. Next slide, please. Okay, so the next document is the actual purchase agreement, and this is really the most important agreement in the transaction. It is a binding document, and it sets out in detail the price, who pays what, whom, when, and it talks about any non-competes, has, as Jennifer put it, risk allocations, you know, who bears the risk of certain things going wrong. This is really your documentation. If there is a lawsuit because the transaction has gone south, they will be looking to the purchase agreement. So this is the document that really needs to have a lot of time and effort spent on it. And again, you cannot just pull something down from the internet and fill in fields, and you cannot necessarily copy and paste entire documents from one transaction to the other. So you want to make sure this is negotiated and reviewed very carefully. This is where your attorney will earn their money. And again, you want to make sure that it has all of your intentions. You know, so just because somebody says, oh, well, you know, yeah, it's got a non-compete in it, but don't worry, we're not going to enforce it. Those verbal assurances are not valid. They do not hold water in a court. The document, the purchase agreement, is what will rule. So you want to make sure that anything that is in there that you agree to is reflected in the purchase agreement. Next slide. The purchase agreement is going to vary depending on what kind of transaction it is. We have an asset sale where the buyer purchases or acquires certain listed identified assets, properties, and liabilities, but not the seller. And what you get is there is a new owner and a new tax ID number after the closing. You have a stock sale, which is where the purchaser buys the seller's what's called an equity interest, but basically stock in the entity, and then requires the entire business lock, stock, and barrel. And in this situation, you're going to have the same legal owner and the same tax ID number after the closing. You can also do a merger, which is where the two companies come together and they form an entirely new entity, or again, one company can merge into the other. I have actually done a year's worth of cleanup work on a transaction that was allegedly an asset sale, but kind of a quasi stock sale. And again, with all due respect to the parties, they attempted to do this without attorneys, and they made a complete mess of it. And as I said, we've spent a year fixing it. We've had 2 lawsuits relating to the purchase. So you really want to make sure you know what you're doing. Is it an asset sale? Is it a stock sale? Who is doing what? What are the terms in the purchase agreement?
And I would just add to that, this is Jennifer, it's really important to understand, because you're taking on much different risks in the different kinds of transactions.
Right.
And not only that, there are different regulatory requirements that are going to apply both at the state and the federal level, depending on what kind of transaction you've entered into. And if your documentation is unclear, you can be faced with a scenario where you intended one thing, but it looks like another. And when you try to explain that to a regulator, it can get kind of dicey at times. So, this is where your lawyer can help you not only properly document it, but make the best decision regarding the kind of transaction to engage in. Asset sales are great if you're trying to limit certain liabilities from passing from the seller to the buyer.
Yeah.
But they take more time. They just do from a regulatory and licensing perspective. But there can be good reasons to do it. Stock sales can be much faster, but you're buying every single problem that business has unless you solve it before you close. So, there's pros and cons to both, but I don't do many mergers. I've worked on a couple, and historically they tend to be bigger entities, much less common with smaller transactions. But that being said, I think we're ready for the next slide. Heidi?
Yeah, and I was just going to say, I think, I see way more asset sales just because of the unknown liabilities that you're purchasing for a stock sale. I mean, you can do the best due diligence you think is possible and still be surprised on the back end. So I personally see more asset sales than I do stock sales, and people are willing to deal with the time lag in getting your licenses and certifications and so on. Again, depending on, sort of what the scope of the transaction is, but are willing to deal with that, as opposed to dealing with a stock.
Yeah, I definitely see more stock sales, but they come with a heavy dose of your lawyer explaining the risk to you. And I would say asset sales used to be really, really hard to get through the change of ownership process with Medicare. It's gotten a lot better of late. I think I've done 2 or 3 asset sales over the course of the last year. And what used to take a year to get paperwork processed through Medicare is now being done in maybe the 5 to 6 month range, which is lightning fast for Medicare.
Right.
So, I'm less hesitant these days to recommend asset sales when they fit the transaction, and people are more willing to accept the timeline, like you said. And with the understanding that you're never going to necessarily get rid of the Medicare and Medicaid liability if you take assignment of the provider agreement, which is the default in these transactions. But you do shed other problems that the business may have, tax liabilities, vendor liabilities, other things that you may not want to have to deal with. So I'll stop. Sorry. Go ahead, Heidi.
No, that's fine. I mean, I think that's entirely appropriate. You know, that we have, you know, we see slightly different things, which is the value of having two people do these, so that
Right.
the listeners can have multiple perspectives. Okay, so a couple of unique healthcare issues in typical transactions. An asset sale, obviously you are purchasing assets, but a home health and a hospice generally don't have a lot of hard assets. It's not like a physician practice where you've got examining room equipment. You might have radiology equipment. You've got computer equipment. You might have some of it, but not a whole lot. Really, most of your value is in goodwill. So this is, as Jennifer said, not as common in home health and hospice. You know, you take on your Medicare, Medicaid billing liabilities, but no other liabilities. And again, as Jennifer said, this is common where you have sort of non-healthcare related debts. The stock membership sale, this is again where the ownership of the agency does not change, only the owners of the stock change. That sounded kind of confusing, but if you have ABC Corporation is still in existence. It's just the owners of the shares of ABC Corporation are changing. So again, you take everything on in a stock or membership sale. And again, merger, we don't see as much of those. Really tends to be more asset or stock sale. And again, you know, any successor liability is going to depend on how you structure your transaction. Next slide, please.
So we want to spend a little time. Yeah, we want to spend a little bit of time on some key provisions in the purchase documentation. Certainly, your purchase price and compensation structure are really important, but it's equally important to understand what these representations and warranties are, what they mean, and why they're important. So reps and warranties are made both by buyers and sellers, although certainly the seller reps and warranties are far more important and far more detailed than any rep or warranty a buyer makes. But they're essentially legal statements that confirm that certain facts or conditions are true. And they're everything from, if you're in a stock sale, they're going to affirm that the entity is in good standing with the state and all of its filings are up to date. They're going to make representations and warranties about things like, we don't have any pending litigation that we haven't informed you about, and if we do have any, it's on this schedule that we're attaching. So an inaccuracy in a rep or warranty can be grounds for a buyer to sue over a breach of the contract or an untruthful or some rep or warranty that wasn't accurate. But 99% of the time what happens is they seek indemnification under the indemnification provisions in the purchase agreement and basically say, I've been harmed to this extent, this amount of money as a result of your inaccurate representation or warranty, and you are contractually obligated to make me whole for that loss. We'll talk a little bit more about indemnification on a later slide. But common examples of reps and warranties are things like you're going to promise that your financial reports are accurate and complete. You're going to disclose whether there's any pending litigation or audits. And you're going to affirm that the business is in compliance with applicable law. When I'm representing buyers, my job is to make sure that these are true. And if they need to be caveated or explained or certain things need to be disclosed, that gets done in the purchase document. The worst possible thing we can do is have a buyer and a seller sort of verbally disclose things to each other and not write them down. So my job when we're drafting reps and warranties and disclosure schedules is to make sure that all those things you've talked about get written down on paper and that I ask all the right questions. In home health and specifically in home health and hospice, we're going to cover some of the sort of unique reps and warranties. Let's go to the next slide. We have some things in the healthcare environment and especially in home health that are in hospice that are important. So we're going to make, buyers are going to make representations and warranties about licenses and certifications and contracts that are necessary to operate their business and that those are current and in good standing. They're going to make a representation and warranty about the status of their Medicare and Medicaid enrollment, whether it's active, Sometimes it covers revalidation. It can cover any number of sort of things that surround that Medicare and Medicaid enrollment. We're going to probably make representation and warranties about the owners not being subject to disciplinary or corrective actions or appeals. Sometimes those are relevant. It really depends on the business, and it depends on the owners and their status. We're definitely going to make representations about exclusion screening, as Heidi alluded to. She had a deal where somebody had employed an excluded person. I've also had a deal like that, where we found out after the fact that we were representing the buyer, and they kind of did a quickie deal without counsel and came after the fact and said, hey, we've discovered that this person who worked for the business was excluded. And, you know, I won't go into painful detail on what that means, but let's just suffice to say that it'd be something you really rather know in advance, not find out after you've already bought the business. So exclusion screening is really important. Background screening, if it's relevant to the kind of business you're running and the type of staff you employ. Sellers are going to have to make reps and warranties about that. You're going to make representations about claims, enforcement and other actions, administrative proceedings, audits, investigations. I try to make this as broad as possible when I'm reviewing these for a buyer. I want to know what's been going on from a compliance and regulatory perspective with the business. Are there, are you in the middle of TPE? Is there a probe audit ongoing that you don't have results on? Or is there a large post-payment audit going on that you don't have results on? This is the time to cough up the information and put it down on paper, because if you don't disclose it and you knew about it as a seller and there's a negative effect as a result of it later on, that buyer is going to come back to you under the indemnification provision in that purchase agreement to be made whole. So it's absolutely essential that everybody's transparent at this point. We need to know the problem.
For those of you taking notes, this is where I would put in the margins, open kimono.
Good. Excellent. Yes. Transparency is key here, because you really get yourself in a bad situation if you fail to disclose things. You open yourself not only to the indemnification actions, but you open yourself up to claims of fraud, fraudulent inducement, and all sorts of other tort actions associated with these kinds of deals that can make a seller individually liable to a buyer. And you don't want that. So it's real important that your kimono is open, as Heidi said. Last but not least, in a home health deal, a seller, I'm always going to include in my documentation something that addresses the 36-month rule. If you don't know what that is, essentially what it means is a home health agency can't have a change in majority ownership more often than every 36 months. It's important to trace the ownership history of a home health agency, whether you're representing a buyer or a seller. This is something that we can deal with in the context of a transaction. If you're not quite at that 36-month timeline yet, there are ways we can structure transactions around that. You can do interim management arrangements, but we need to know it, and you need to be transparent about it, because if you unknowingly or unwittingly, as a buyer, violate the 36-month rule, I've just cleaned up a deal for somebody where this was an issue, and they spent a whole lot of money paying me to fix it that they could have avoided if they'd simply engaged counsel before they decided to do a change of shareholders a month after they were initially certified. So just lessons learned there. So let's go on to the next slide. So the next sort of most important provision, absent the purchase price and those reps and warranties and sort of the other mechanical things you got to get covered, is your indemnification language. So indemnification protects the buyer ordinarily. There is usually mutual language that also protects the seller, but the financial exposure for the buyer indemnification is pretty low. It's really much more important that the buyer get the seller's indemnification for what we call pre-closing liabilities and for breaches of those reps and warranties, or situations where those reps and warranties may not have been fully accurate. The job of any good lawyer is to help negotiate these, I guess, and everybody's going to advocate for their particular client's position, but go ahead, Heidi.
Yeah, and my comment is just indemnification is not a complete, but a partial backstop against stuff failing to be disclosed. So this helps you out in that regard. So you want to make sure your indemnification provisions are strong.
It is, and we're going to talk about qualifications and exceptions on the next slide. But indemnification is, generally speaking, a provision that says, as the seller, I promise to make the buyer whole if there's some pre-closing liabilities that pop up after this transaction closes. And it's going to lay out exactly what kinds of liabilities or losses that seller is going to cover. And it's sometimes you attach a cap on that liability, sometimes you don't. We'll talk about that on the next slide. But you're going to definitely put some boundaries around what this provision does and doesn't do. It's also a good indemnification provision. It's going to lay out the process for the parties to communicate with each other about an indemnification claim. And that can be almost as important as what the indemnification is itself. I've actually worked on a project where we represented a seller and the buyer made an indemnification claim, and there was a real dispute over whether the buyer timely made that indemnification claim because it involved an audit of pre-closing time periods. And the buyer didn't tell the seller until months after they had already submitted records in response to this audit request, and they did a not so great job of responding to the audit request, and it really hampered either party's ability to defend the claims. And at the end of the day, you know, they kind of got bogged down in whether the seller really owed any duty to the buyer because the buyer had failed in sort of every respect to tell the seller there was ever even a problem and allow the seller the opportunity to try to defend the claims. So it's important not just what the indemnification says, but also, you know, what liabilities it covers, but also the process gets laid out clearly. Let's go to the next slide. All indemnification clauses are going to have qualifications and exceptions built into them, and those are really anything that limits the party's liability, whether that's the buyers or the sellers. It can include a cap on total liability a seller, for example, is willing to indemnify you for. But it can also say that you're not going to come bother us if that liability is less than $1,000 or something like that. These are always negotiated, and it definitely can become sort of one of the key points as you're developing your purchase documents. You've really got to work through this between the buyer and the seller's counsel usually. Often we include materiality qualifications. Those can be built into the reps and warranties themselves, or they can be built into the indemnification, or both. And that basically says, usually it's something like, seller is only going to indemnify buyer against material breaches of reps and warranties, things like that. Materiality is a term of art in law. Basically, it means we're not going to bother each other with the really little stuff that's not what we call material. But keep in mind that what one person thinks is material doesn't necessarily match what another person thinks is material. So while we often throw this term around, it can sometimes be really hard to define. And I've actually spent time in some deals defining what material means with more definitive terms. So just something that transactional lawyers are often want to spend some quality time working through this stuff so that everybody kind of knows what they're getting themselves into. The time limit on indemnification is always an issue. The sellers don't want to provide, you know, indemnification forever. They want to put some kind of time limit on that. When I'm representing buyers, I always want to push for that time limit to be the statute of limitations for whatever laws are relevant to the transaction. Generally, we're looking, you know, as a buyer's counsel, I want 4 years minimum because that takes me through the entire period of time. Medicare can come back and audit those claims that right up, you know, to the day of closing. Most sellers don't want to give you 4 years, and you usually end up somewhere in the middle there, but every single deal is unique, and the facts of any particular deal kind of drive that conversation and what those time limits end up looking like. Oftentimes there can be concessions between the parties on purchase price that affect what these time limits and indemnifications ultimately look like. You know, you'll pay a little bit less for the deal, but they'll get a little bit, less indemnification. Again, everyone's very fact specific. These are all very, very negotiable. So it's important, though, that you've got good representation when you're going through this process to help you understand not only what your options are, what you're agreeing to, what the sort of legal impact of that is. Let's go to the last slide here. We're going to start talking about closing. A closing is when you actually sign over legal ownership, either of the assets or of the equity in the company. It can sometimes occur on the same day a purchase agreement is signed, but in most home health and hospice transactions, that's really not how it happens. Generally, you're going to negotiate all of the terms of your purchase agreement and sign it, and your closing is going to be delayed. Sometimes 30 days, sometimes 60 days, sometimes somewhere in between those two. Often that's driven by the notice periods for things like licensure, depending on the kind of transaction that you have, or if there are any third-party consents that you have to get to the transaction, or things, sort of interim steps you got to work out between agreeing what you're going to pay for the agency and how that's all going to work, and actually closing and transferring ownership. In Texas, a true chow, and when I say a true chow, I mean an asset sale, where you've got a new owner with a new tax ID number after the transaction. It requires a minimum of 30-day advance notice to Texas Health and Human Services, because you have to file a new license application and pay a new licensing fee. You can fudge that 30-day window. I don't advocate that you do, but you can pay a late fee. It can be done, and I've certainly worked on transactions where we've given less than 30 days advance notice. But I often counsel clients, you go into that understanding that anything less than that, and you're going to be pushing really, really hard through your due diligence, you better be able to dedicate a lot of time to that transaction in that intervening period between when you start working on that purchase agreement, ultimately sign it, and when you close that transaction. A conditions to closing provision is always an important part of your transaction document, and these are all of the things you basically lay out a set of conditions that must be met before you can close the transaction. And if you don't meet one of those conditions, then it's grounds for either the buyer or the seller not to close, depending on how you've drafted the provision. For example, if a buyer is trying to get outside financing and that financing falls through, then there will be certain rights afforded to either the buyer or the seller to either delay the transaction or terminate the transaction or renegotiate the timeline because that condition to closing hadn't been met. So when I'm preparing for closing, I'm going through my checklist, which is in the purchase agreement, of all the conditions of closing that have to be met to be able to close that deal. Let's go to the next slide. Once I can confirm all those conditions have been met, then we can proceed to closing on whatever date we have chosen for it. And at that closing, everybody's going to review the final documents, which are generally a bill of sale or a bill of sale and assignment, which, depending on the kind of transaction you have, that document may look a little bit different. And then you may have financing documents that you're signing. You may have promissory notes that you're signing, security agreements that you're signing. There could be, as Heidi had mentioned, there may be employment or consulting agreements that are going to go on after closing, where maybe some staff and the buyer are going to stay around for a while or permanently. But there's always a fairly, a packet of documents that you're going to sign at that closing. And the important thing to keep in mind there, not only does the money generally change hands then, and your escrow accounts will get set up and funded, but that's the point at which you legally transfer ownership of the business. That's that effective date we always talk about when we're doing licensing and certification applications. So let's skip to the next slide. Heidi, I think you were going to talk a little bit about post-closing stuff.
Yeah. So, and as Jennifer said, just because you go to closing, just because you sign the documents, just because you get a check in your hand or you pay a check, usually doesn't mean your relationship is ended. There's a couple of things that can happen. Some buyers want a transition period where the seller stays around, maybe 30, 60, 90 days to help with the transition, retain employees, retain patients. be available in case there's any questions for audit. There's a bunch of different scenarios, but we need to remember that the buyer now is running the business, as Jennifer said, from the date of closing, from the effective date, and now the buyer has all the challenges, all the liabilities from that date forward. So if there's any, thing that goes on during this period, the buyer can now seek a legal remedy for, failure to meet the terms of the purchasing agreement. And of course, the seller during a transition period is to minimize his or her or its exposure to any liability. As Jennifer mentioned, some transactions have deferred payments. Again, it sort of depends on how you structured it, but you're going to rely on each other to comply with the deferred payment obligations and, of course, any reporting, for tax purposes and so on. Next slide, please. A lot of deals also have restrictive covenants. These are your non-compete covenants. Now, some, again, may protect the buyer. Again, a non-compete, a non-solicitation government covenant, which says that the seller is not going to take employees or solicit employees or patients to leave. And a non-compete is, not entering into a competing business in a defined time and geographic area. There may be covenants that the seller has taken on, agreeing to employ the employees, maybe some pay or severance if they decide not to take over the employees. So these are some of the things that are out there. And again, these are very common. I actually get a couple of times a year questions about non-competes and non-solicitation things. So it's very common to have these as being a dispute afterwards. And these are all covenants that you need to have reviewed by an attorney. In Texas in particular, non-compete agreements usually, well, not usually, they're limited in scope by geography, time, and practice area. So what may in one industry be okay to have, a 2-year non-compete for the state of Texas may in your particular circumstance not be acceptable. Maybe you do a year or 18 months, with a radius of 10 miles from the offices. I mean, there's a whole bunch of ways that you can do these, and they really need to be reviewed by an attorney. Next slide, please. So these deals, again, typically have post-closing purchase adjustments based on updated valuations of the business, sharing of accounts receivable. So again, if there's a payout of the AR, you're going to have to be dealing with each other for that point of time. And again, your purchase agreement should define how any of this AR is to be split and how you do the accounting for it. Again, at some point, the seller is going to be out of the loop entirely. So you need to figure out how the seller feels comfortable with the calculations on the AR split while also not giving them, too much information. So this is kind of a dance that we see. We see buyers, they may want purchase price adjustments because again, if you have sort of a 90 or even 120-day period from signing the letter of intent to actual closing, you don't want the seller to basically say, okay, I'm done, I've got my price, I'm out of here, and then the business falls apart during these negotiations and the due diligence and the closing. So you want to make sure that you have the seller maintaining the business at the level that it's been at, and you can do these with the covenants and adjustments afterwards. And of course, you need to kind of file your Medicare and Medicaid change of information or change of ownership. Applications timely. You have 30 days after closing to do it. Again, it's I have seen circumstances where people just kind of forget to do that. They're now so busy running the business, they forget to do that. But remember, you do have some deadlines on those issues there. Next slide, please. Jennifer?
Yes, I was just going to dive in and wrap things up here. I see that we're up at we're a little past 1 o'clock, but we'll keep talking if you want to keep listening. So some special issues in home health and hospice, sort of post-closing type concerns, but also as part of the overall transaction. So we said before that licensing requirements may drive your transaction timeline, and I just wanted to summarize those so you kind of have one slide you could refer back to about this. So in Texas, under our particular law and regulations for licensing, asset sales, where you have a change in the legal owner of the business, like I said before, ideally you give 30 days advance notice, file your licensing application no less than 30 days in advance, and pay your fee. That's all done through Tulip now. I've actually been through one of these. It worked pretty well. I was reasonably happy. There's some decent instructions now out there from the folks that run the Tulip licensing website on how a buyer does this. And I can say that we successfully navigated it with an asset sale earlier this year. The equity transactions where you have a change in shareholders or members, but the legal owner of the business stays the same, so that ABC Corporation stays the same, but the shareholders or members of that entity change. There was a change in Texas law a couple of years ago, so those are no longer considered changes of ownership under the licensing laws. They're characterized the same way Medicare characterizes them, as simply a stock transfer or a membership interest transfer, and they don't require advance notice to Texas HHS any longer, but they do require post-closing notices and things that do have to be filed in Tulip. And there's a fairly short timeline to do that. So you don't want to forget about it. It is important that that gets done, but it no longer requires an advance filing with HHS on the licensing side. In both asset and equity deals, I added this to this presentation because I recently handled a transaction. It was actually an asset transaction that involved a primary home care contract. So these are the Medicaid waiver contracts for certain kinds of services in the state of Texas that are funded through the Medicaid program but administered by HHS and HHS, what used to be HHSC. These contracts, the rules for these are the same and have been for a long time, and they don't match up with the licensing rules and regs anymore, which is frustrating. So if you have buyers, if you are looking at an agency that has one of these contracts, and you're either going to do an asset sale or there will be a change in majority ownership of an entity, so a stock transfer that is going to change the stock or membership interest ownership by more than 51%, then you have to apply for a new contract. And it is a mandatory 60-day in advance contract filing for that application. So there's no way to shortcut that. You absolutely have to do it 60 days in advance. It's a huge pain, I will say. That contract application package is one of the most detailed packages I've ever had to put together. It's worse than Medicaid. And the good news is that the folks we worked with at the state to get that thing approved were good. They were, answered questions, moved things along fairly quickly, and it did get done in that 60-day period, but they absolutely insist you must file that application package 60 days before you close. So that can draw your timeline out quite a bit. Often, if you have these long time lags between sort of signing your purchase agreement and closing your transaction, the buyer may want to come in and manage the business in the interim. Often that's necessary both because they want control, but also because there's some financing and funding issues, and buyers can, provide a source of funding to keep those businesses going when sellers are tight on money. It can address 36-month rule issues where you may be waiting for a 36-month period to run out in a home health deal so that you don't trigger that 36-month rule, which for those who maybe aren't familiar with it, I said before, you can't have a change in majority ownership of a Medicare certified home health agency more often than every 36 months. That's a Medicare rule. And if you do, they will pull the certification. And essentially, the buyer has to apply for a new certification for the business, which, as everyone knows, can take quite a bit of time. So it's real important to know if that's going to be an issue in advance and to build it into your transaction. Often what I've seen, if you've got, let's say, 6 months before that 36-month period is going to run out, you'll do all your transactional documents, you'll sign your purchase agreement, you'll set your closing for a day after that 36-month period expires, and the buyer will come in and manage the agency in the interim. But you've got to build that into your deal. And that management agreement needs to be negotiated, needs to be part of the deal so that everybody understands, sort of whose responsibilities, where the responsibilities fall, where the liabilities fall. Let's go to the next slide. It's really important to also keep in mind, a lot of the Medicare, a lot of the hospice and home health business it is Medicare or Medicaid. But we also have a fair amount of private payer contract coverage for this kind of stuff, private insurance that covers home health and hospice services. And those can be very important contracts for some businesses. So it's important to look at, when you have one of these kinds of transactions, what are the payer contracts or the price? You kind of look at who are the top payers for a business. Look at your contracts with those payers and examine the assignment provisions and see if this change in control or if there's an asset deal, what I call a true chow, what's going to happen with those payer contracts in the context of the transaction? Are they assignable? Do we need to get consent? Are we going to have to do a new contract? You need to be planning for that on the private payer side as well. Retaining staff is always an issue, and it's always something that it's the softer side of these transactions that the operational folks really work hard on making sure they retain key staff and patient care staff. Many of these transactions, especially if you have a fairly large agency, you're taking care of patients, and it's real important that you're able to do that transaction in a way that's transparent to the patient. You want the patient care to never be interrupted and be as smooth as possible. And so it's important that you address the staff and make sure you've got key staff on board. And you've got a plan if for some reason you do have some people leave because they just aren't happy with the transaction or for whatever reason, they just decide it's time for them to move on. Buyers and sellers need to work on these things together. These transition periods can be, tense times for the staff of these businesses. So I do see a lot of effort put into, it's not so much the lawyer's job, but it's my job to basically, remind everybody, the seller is going to do everything they can to cooperate and retain staff and patients, and the buyers are going to, play nice with everybody and talk to staff, and to the extent there are key positions, they're going to make sure that they're having those conversations and doing it in a way that the seller's comfortable with. I caution everybody, don't forget about accreditation. If you have an accredited agency that's involved in a transaction, there are notices required to that accreditation body about these, either a change of ownership or a stock or membership interest transfer. 99.9% of the time, it's a simple notice letter that needs to go in, but it needs to happen. It's going to be asked for as part of your, usually your licensing notices. So don't let that fall through the cracks. Be sure you get in touch with CHAP or a Joint Commission or whoever you're accredited with. Heidi had mentioned earlier, it's important to review a seller's compliance plan policies and procedures in any audits, whether those are internal or external. I second that wholeheartedly, sitting down with the agency's compliance officer and talking with them in detail about the history. Making sure you're aware of audits, looking at audit reports, finding out what's pending, and doing your internal claim audit is all really important through the due diligence phase of any transaction. And then buyers are always looking at cost-saving strategies when they buy a business. So you're always looking for ways you can remove redundancies, streamline technical and administrative systems, looking at outreach and marketing efforts, and sort of generally understanding if this is a good deal for you. Is it a good fit? So let's just go to the last slide. So in conclusion, transactions they're complicated, and the facts of any particular deal vary. Every single deal is unique, and as we said in the beginning, these can be lengthy processes, and it's always better to do your homework in advance, engage an attorney before you get deeply into the conversations so that you're planning for this stuff in advance, not trying to fix problems on the back end after they've already happened. We've kind of hit some highlights talking about fraud and abuse issues that may pop up, talking about leveraging those experienced professionals that understand how transactions should be documented and the important factors and issues that need to be addressed, talking about valuations, and talking about long-term risk allocations for things that go on after closing. You know, transactions I enjoy working on them. I enjoy working with people who are looking at growing businesses. They're probably one of the most rewarding parts of my practice. I just really love working on deals with folks who are doing this, but they're very nerve-wracking for buyers and sellers who, I mean, they've got a lot of time and money invested in these things. Oftentimes it's their primary livelihood. So, you know, our job as the attorneys is to support you, make sure that you've got all of the information you need to go into these things and make good decisions and understand the choices that you make in these transactions. So with that, Heidi, if you have anything to add, we're happy to stay and answer a couple questions.
Agreed.
Here's our contact information. If you're welcome to email or call us if you have a question after the fact. And if anybody has any questions, we can try to address those. I've got about 5 more minutes I can stay on the line.
So we actually have about 3 questions. So I'll start with the first one. She's asking, we have an unburdened, licensed, and certified agency. We stopped seeing Medicare patients 3 years ago. No Medicare billing in 3 years. We still have an active pass agency with Medicaid enrollment. Is the Medicare license worth anything to the buyer?
I would say it depends. I have a deal actually right now I'm working on in another state that is sort of similar. What we discovered was that the agency itself hasn't been terribly active for probably about 18 months to 2 years. And in that period, Medicare sent a revalidation request and it was missed by the people that own it currently. I'm representing a buyer in that scenario. So they have a PACOS record that looks active, but they're actually deactivated because they didn't file a revalidation application. So in those scenarios where a business may have been sitting on a shelf for a while and you haven't had active patients, you haven't been filing claims, it's very important to figure out what the status of that enrollment is as of today, and determine if there is an issue with it, if it's been deactivated or it's been revoked. It kind of leads you down different paths and there are different options for what can happen at that point. If you've just been deactivated because you failed to file a revalidation application, it's fairly simple to get it reactivated, although it does take some time. If you've been revoked, it's a different scenario, and it really depends on how long it's been since that happened and what the reasons were behind it. And I don't want to get deeply into that. So the answer to your question is it depends, but with a little bit of homework, you could certainly sort out what the options are.
Thank you, Jennifer. Okay, so the second question is, can you elaborate on the Stark law in cases where an agency medical director refers patients to that agency? The medical director is being paid by the agency, but not being paid for the patient referral.
Medical directorships are common with home health and hospice, and the Stark provision we were talking about earlier in the presentation really has to do with ownership, not contractual relationships. So when you have medical directorships, you're really subject to different exceptions than the ones we were talking about. Under Stark, you would be looking at the personal services exception, and there are specific criteria that your contract with the medical director has to meet under that Stark exception. And that would apply to home health medical directorships. On the anti-kickback side, there is a safe harbor for personal services contracts, very similar to the Stark exception, and it would apply to home health and hospice medical directorships. So as long as you structured, safe harbors are optional, but we often counsel clients on what we think are, how do you get as close as possible and what's common in the industry for medical directorships. So long story short, it's not as much of an issue in a transaction. We were really focused on physician investment in home health and hospice. Those medical directorships are contractual relationships. They're subject to different exceptions. So I think that answers the question.
I actually have something to add here, and that is where I have run into circumstances where an owner of an agency is married to a physician, but you wouldn't necessarily know because they have different last names. And if that's the case, you may have Stark issues, so you really need to kind of suss all of that out.
Okay, we'll take one more question. She's asking, does the 36-month rule apply to hospice? If so, could a newly certified hospice sell Measure T ownership to another partner?
It does not apply to hospice. It only applies to home health.
Right. Okay. So thank you, Jennifer and Heidi, for this amazing information, and thank you everyone for attending. For those of you who are asking about the slides, everyone will get the slides within 24 hours. And with that, we conclude our webinar for today. Thank you again, Jennifer and Heidi, and see you all next time.
Thank you.
Thank you all for participating. Bye-bye.